The off-docket initiative is one of many different approaches that EOIR has been using in terms of how it manages the cases that are on the court's dockets right now. The broad context here is that it's very clear to us that EOIR and the Department of Justice are making attempts to reduce what is now a 2 million case backlog right now that is overwhelming the immigration courts, as many of you know on a day-to-day basis, given your practices. And on average, we are talking about a wait time of 4, 5, or even 6 years for asylum cases and other kinds of cases to go through the immigration courts. That is way too long. And not only do your clients feel it, not only do you feel it, but the government feels now the political pressure that it has to be able to address the backlog so that the courts can actually run efficiently, and also from our viewpoint, and I hope the court as well, fairly to ensure fairness in cases that are before the courts. A piece of background here in terms of AILA's interest and engagement on this. Before the Biden administration actually even came into office, and before actually President Biden was elected to office, AILA began developing proposals in the hope that a receptive administration would be coming into office in 2021. And among the proposals that we presented to the transition team for the Biden administration was a proposal that would actually take some of the form of what these current initiatives are that we're going to present to you are all about. Our interest here was that there are many cases that are currently occupying time and space on the immigration court dockets that don't need to be coming before an immigration judge, perhaps because USCIS has a petition before it on that same case that you have filed on behalf of your client. And from our viewpoint, why should a case be taking up court time? Why should your client or you as counsel be appearing in those cases and taking up your valuable time or the court's time when in fact USCIS may have jurisdiction and could resolve it? Those types of situations, from our viewpoint, were the ideal situation for the court to say, hey, let's remove this case from the docket. Let's find a way to resolve it. We actually proposed not only that case to be removed from the docket, but things like administrative closure as other options, which we'll be talking about in a moment. AILA worked actually with the Cardozo Law School in New York, which crunched some data and found that at the beginning of the Biden administration, there were about 700,000 cases that could be resolved in a more expeditious way and that didn't require court time. The vast majority of those cases, by their estimation, this is Cardozo Law School, about 560,000 cases back in 2021 had petitions that were pending before USCIS. So from AILA's viewpoint, DOJ and the immigration courts, as a matter of policy, really had to look at this issue. We know now over the past couple of years in our engagements with EOIR and with DOJ, many of which this EOIR National Liaison Committee that AILA members have been leading, Amanda and Ashley both being members of that, that we know that DOJ has a lot of attention put on reducing the backlog, and that's what some of these initiatives are all about.